Hello, my name is Michael Tesoro and I've prepared this ACCC Video Case Note on the application by the Port of Newcastle to the Australian Competition Tribunal. Bit of background about myself. I'm a competition and consumer lawyer and I've been working in my own practice, Sarah Legal Consulting, for the last 13 years. That role I've done a lot of work in relation to competition and consumer matters and also done some authorisation work for clients. Prior to that, I worked at the ACCC for 15 years in a variety of roles in enforcement, mergers and asset sales. Also did a short stint early on in the adjudication branch. Outline of the presentation, I'll discuss the background and history of the application, then look at the ACCC decision, spend quite a bit of time talking about the tribunal decision, and finally have some commentary. Now, the background to the application, it was an application by the New South Wales Minerals Council for an authorisation for a collective bargaining arrangement on behalf of all those coal companies, which are the major coal companies in the Hunter Valley area. So they're seeking permission to collectively bargain with the Port of Newcastle. Now, the application sought three things. Firstly, to allow the coal companies to collectively discuss and negotiate terms and conditions of access with the port. Also to discuss among themselves related matters, and finally to enter into a collective agreement and give effect to that collective agreement with the port. Now, the applicant made a range of submissions in support of their application. The first submission they made was that since the revocation of the declaration in 2019, the port was not subject to any constraints on its pricing power. So effectively what that means is that the port's had this funny history where it's been declared, not declared, then declared again. But currently it's not declared, and that means that there's no access regime which applies, which means that effectively, at least in theory, the port has significant pricing power. And the second submission they made there was that since privatisation of the port and the removal of the access regime, there have been significant increases in both the navigation and wharfage charges. Now, the applicant made further submissions about the public benefits. The first thing they claimed was that if it was permitted to go ahead, there'd be increased certainty for investment in the Hunter Valley, which would facilitate employment and growth in the region. It's sort of a very big claim and one that needs to be able to be substantiated. There'd be transactions cost savings, so instead of each of the individual coal companies going to P&O and having a separate negotiation, there'd just be one big negotiation, which would save everybody a lot of time and money. And then a number of other material increases in competition in dependent markets. So they're referring to the coal export market, markets for acquisition of exploration and mining authorities, as well as these associated markets, drilling services, etc. And these are all very big claims, which ultimately you've got to be able to prove. The applicants also claimed that there was low public detriment arising from the agreements. The first thing was that the agreement would be voluntary, so there wouldn't be an obligation for all the coal mining companies to participate. Also, there was no requirement on the port to negotiate collectively. But the key factor was there's no provision in the agreement for collective boycott activity. So the parties weren't seeking permission to actually collectively boycott the port if they didn't get their way in terms of access and pricing. So that's a very significant exclusion, which reduces the level of public detriment significantly. And the final point they made was that the port currently publishes various issues related to access terms and potential pricing issues. So they believe that there was low risk of collusion between the coal companies coming out of this particular agreement. So on the 2nd of April 2020, the ACCC granted an interim authorisation which permits the parties to start talking. And then on the 27th of August, the ACCC granted a final authorisation to the agreement for a period of 10 years. Now, in this decision, the ACCC firstly spoke about the public benefits, and as you can see, they accepted most of the submissions made to it. They believe that there'd be public benefits arising from giving the coal companies greater input into the terms and conditions of access, that it increased transparency around capital expenditure plans, cost allocation. There'd be greater certainty for delivered prices, more timely resolution of industry issues. Also, that the agreement would enhance international competitiveness of the Hunter Valley, the coal industry, and improve investment and employment benefits. So these are very large public benefit claims. And then finally, the ACCC concluded that having collective bargaining would significantly reduce transaction costs. On the detriment side, the ACCC formed the view that the detriments were minimal. And again, they've accepted the submissions made, that it's a voluntary scheme, there's no ability to boycott. There's also the ability to negotiate separately outside the agreement, and they thought the risk of collusion amongst the coal suppliers was low. Because it didn't involve a discussion of coal projection, volumes, customer pricing information, or marketing strategies. So these confidential issues were outside the agreement. Now, the first issue the tribunal's got to consider is what would be the factual, what would be the future situation if the authorisation was granted. And the conclusion which was reached by the tribunal was consistent with what the economists had submitted to the tribunal, which is firstly that if the authorisation was granted, the coal producers would be able to discuss terms between themselves. They would also be able to negotiate with the port about those particular issues and come to an agreement, but they still would have the ability to negotiate individually with the port. So that would be, with or without the authorisation, they still have that ability to individually negotiate. The counterfactual is what would occur in the future without the authorisation. Well, the conclusion there was a coal producer would not have the ability to discuss issues between themselves. They would not have the ability to negotiate with the port. However, they would still have the ability to negotiate individually. Now, the tribunal decision made a number of conclusions, and they're quite a lot scattered throughout the decision, so I tried to summarise them here. But the key issue that the tribunal was not persuaded that the collective bargaining conduct was actually going to bring about the change with the parties believed it would, that could also be achieved through bilateral negotiations. They noted that the port had very little incentive to change the level of navigation service charge that it was currently charging on the deeds. The negotiations which occurred between the coal producers individually and the port were likely to result in the same outcome that would be achieved from a collective negotiation. The tribunal also noted these pricing deeds which the port had put out, which contained a number of uniform terms governing material price increases. So it's likely that prices for all the coal producers would have gone up in lockstep. Furthermore, there was a most favoured nation clause. So if one producer was able to negotiate a better price, then that would automatically be extended to all other coal producers. And finally, the view was that the arbitration provision under the pricing deed would most likely result in all the coal producers' disputes being consolidated and there being a consolidated arbitration. So the tribunal didn't see a lot of these benefits actually manifesting themselves in the future. They were also critical of the evidence put to the tribunal that there was really very little evidence before the tribunal explaining how there'd be an impact on competition arising from the agreement. They were critical of ACCC dismissing the prospect of any anti-competitive detriment in a cursory manner, and that they were not persuaded that the conclusions that the experts expressed about a number of issues should be given any weight, because they claimed that they were just making assertions rather than backing it up with evidence. And that's particularly in relation to the claim transaction costs, which was no real solid evidence before the tribunal that those transaction costs would be realised or what the level of savings would be. They concluded there'd be a small risk of collusive conduct between the coal producers. So that's one issue that they agreed with the ACCC and the economists about. They were very critical of the way the case was presented to them. They stated that many of the contentions advanced by the parties had an air of unreality about them. There were economic theories put to the tribunal, but really didn't draw very carefully from the underlying facts and circumstances. The claims that the collective bargaining would improve contractual certainty was not supported by evidence. The contention that the collective bargaining would reduce transaction costs was not supported by hard data. And finally, there was no evidence adduced about the commercial dealings or arrangement between the authorisation applicants and the port. So these are significant failings in the level of evidence that's put to the tribunal. So ultimately, the tribunal concluded that really the claim that there was public detriment arising from the agreement had not been made out. As far as they could see, there was really no public detriment arising from the agreement. There was no risk of collusion in export coal markets. There was no real detriment arising from the marginalisation of the coal producers' interests. And the claim that it was going to negatively impact on investment decisions was not supported by evidence as well. So the detriments were effectively zeroed. In terms of the public benefits, the tribunal also concluded that none of the public benefits were likely to manifest themselves or be any more than a minimal level of benefit. So they didn't see that there'd be benefits arising from more efficient contracting or even reduced transaction costs. So effectively, the tribunal concluded that the agreement would result in zero public benefits and zero public detriments. One thing they did note, which was important, was the observation that any change in conduct or outcome which has the effect of increasing total economic welfare or surplus is a public benefit. And this arises from the Qantas case many years ago, which imposed or decided upon a total welfare approach. So if less resources are being used in an economic activity, that's a public benefit because those saved resources can be used elsewhere. However, what they say here is conversely, any change in economic conduct or outcome that has the effect of transferring economic surplus between a buyer and a seller without increasing total economic surplus represents a private benefit. So what they're effectively saying there, that if the coal producers are able to exercise power to push prices down, that's not going to benefit consumers. There's not going to be any net saving to consumers or to the economy more generally. So the total welfare standard is not met. It's really a private benefit and accordingly can't be given any weight. One thing that's interesting here is this total welfare standard that we apply in Australia is fairly unique, or I should say unique. I don't think any other jurisdiction uses a total welfare approach. I know the US is very focused on consumer surplus, consumer welfare. So I think we're an outlier on that particular issue. And just a commentary on the case, like it's very interesting. I think the main thing is the evidentiary issues is what resulted in the authorisation being rejected. It doesn't appear that the applicants did enough work to substantiate either or primarily the public benefit claims that it made. I think the claims that they made were a little bit over the top. Like some of those claims were virtually impossible to establish without spending a vast amount of money on various economic analysis, but they didn't do enough on some of the more important and simpler public benefits such as transaction costs. Clearly that's something that they could have worked out, the cost of each party individually going to the port and negotiating terms and conditions versus a collective negotiation. I think the public detriment issue was also one that was just ignored, and really you've got to be putting evidence forward explaining why that isn't a factor. Ultimately, the tribunal agreed with the parties that there was really no risk of anti-competitive detriment arising from the agreements. The other thing that was made much of was the investment decisions of the coal producers. And again, it was hard to see how that claim could be substantiated, given how small a component these particular wharfage and navigation charges are to the total cost of the product being sold. So these are claims which are routinely made in authorisation applications, but really they're almost like motherhood statements which are never going to be able to be established by hard evidence. So I think the tribunal's decision does show that they're not going to simply accept claims made without some pretty hard evidentiary material behind it. Some analysis of financial issues has to be provided. It was a bit concerning how the tribunal effectively ignored all the economists, and I think that's a bit of a concern. I think there's a tendency of the tribunal to do its own thing and maybe not give appropriate weight to economist evidence which is provided. And the final issue is whether the ACCC is likely to appeal this decision. I have no real insights into that. I'd be surprised if they did, because it's not that important a case ultimately, allowing these large coal companies to collectively negotiate with the port. However, I think the interesting takeaway from this particular case is that, firstly, companies that don't like a collective bargaining agreement that has been obtained with the ACCC are going to see strong benefits in appealing those decisions to the tribunal. And it's clear that the tribunal is going to expect a much higher level of evidence and much more comprehensive material on which to base findings of public benefit. So I think that's one lesson for the ACCC, that it needs to make sure that it's getting the evidence it needs and that it's credible evidence before it grants an authorisation, and that if the matter is taken to the tribunal, that the relevant parties are going to have to put strong evidence to the tribunal to get their matter over the line. So that's all I've had. If you have any questions about this presentation, please feel free to give me a call or drop me an email. Bye-bye.